Good day and welcome. Again, Employment Law Show. So good to have you along for the next 30 minutes. Please stick around, guaranteed to learn all kinds about employment law and as it works. Probably where you spend 8 hours of your day, right, for most of your life. So this is really important stuff, and it applies to most people out of a non-union setting as well. So we got lots of stuff to throw at you this morning, or at least today anyway. You want to reach out anytime to Lior, 1-855-821-5900. Lior right there, co-founding partner, Samfiru, Tumarkin, the most positively reviewed employment law firm in this wonderful country of ours, whether you're in Ontario or BC or Alberta, serving all those people and helping people on a daily basis. Tons of phone calls and emails come through every day. We like to get to a few on the show. As you know, help@employmentlawyer.ca is the way to do that. I'll give you more contact throughout the show as we carry on. And on the show today, Lior, it's a big one. What independent contractors need to know. This is one of the biggest vacuums of misinformation when it comes to employment law. We're going to clear a bunch of it up today, so stick around for that. But we always start, my brother, with the week that was. What's going on your side?
I don't know if you'd be surprised to hear, John, that I'm getting a lot of calls, a lot of emails, a lot of questions about workplace rights. That's what I do. You know, I try to squeeze in time to come here and do this TV show because the rest of the time I'm answering questions. I'm trying to help as many people as possible, myself and my team across Canada, dealing with all these workplace issues that the pandemic has created, whether it's severance or temporary layoff or changes to compensation, vaccine mandates, you name it, we deal with it. And it's been a bit of a whirlwind, but that's okay. I'm happy to do it. We're ready to help. And on this show, we want to inform you about your workplace rights. So if you haven't had the best week because your boss maybe gave you an ultimatum and you've been wondering what to do, well, you know, grab a coffee, sit down, and let's talk about it right now. You will learn what you need to do in this situation, how to respond and what your rights are. That's exactly what we want to do. It's to inform you. And information is power. Knowledge is power. That's exactly what the show is about. And of course, you always are encouraged to reach out to me in the office. If what we've talked about today doesn't fully answer your question, if you need help to deal with your employer, we'll give you that contact information so we can have a private chat and get to work. But I always like to start off with a situation that came across my desk. I spoke with a gentleman that's been working for the same employer for a number of years, over 8 years. But recently, his employer decided that because of the pandemic, the same pandemic we're all dealing with, that they're going to change their business model. They're going to go after different customers. They saw different opportunities. But what this meant for this individual is that he's going to have to change his hours of work. So instead of working 8 in the morning till 4 in the afternoon, he's going to have to work from noon until about 8 in the evening. So for him, that was going to be a massive change. And his employer said, well, listen, it's not really our fault. It's kind of the pandemic that's making us do this. And, you know, the person did feel that makes kind of sense because it is the pandemic. It is a very difficult situation. So he called me wanting to know, do they have a right to do this, even if it's because of the pandemic? Can they change my hours of work from 8 to 4 to 12 to 8? So the answer here is actually simple and not controversial. The answer is no. His employer cannot do that. Your employer cannot change the terms of your employment, even if it's because of the pandemic. They can't change you to a different shift. They can't reduce your pay significantly. They can't demote you. They can't say that we're going to now close the factory here and move away 200 kilometers. Any of those changes result in a constructive dismissal. So if you're facing a change like that, it's exactly what I told them, even if it's pandemic related. Whether or not it's pandemic, it doesn't matter. You have the right to treat that as a constructive dismissal. So for him, yes, he can accept the change, and now he's working 12 to 8 if he wants, absolutely. Or he can say, by changing those terms, by telling me that my 8 to 4 shift is no longer available, you've terminated my employment. Now you owe me severance. And I said, John, he was working for about 8 years. He's going to be owed about 9, maybe 10 months of severance. So I'm going to help him get that severance. He doesn't want to work in the afternoons and evenings, but you have the same rights. If your employment terms have changed, even if it's because of the pandemic, the term constructive dismissal should come to mind right away.
Does an employer, Lior, sometimes in this when it comes to change of hours and time of work, do they have a little bit of leeway? I mean, 8 to 4, 12 to 8, that's a completely different shift. But they say we got to move you from 8:30 to 4:30, or even 9 to 5 from 8 to 4. Can they get away with that?
Yeah, there's a little leeway that an employer has. If they were going to change his shift by half hour here, an hour there, yeah, they could probably get away with that unless there's a really good reason why you can't do it. Same thing with pay cuts. Anything less than 10% pay cut is probably going to be something that you're not going to be happy about, but your employer may be able to get away with. Anything more substantial, it's a constructive dismissal. And the good thing is, if you're not sure if the change that your employer is implementing is substantial enough, you don't need to wonder. You just call, email me, let me know what it is, and I'll tell you, because not every change is the same. Small leeway, sure. Significant changes, constructive dismissal.
You probably know the second question I'm going to ask you, and that's this one. If this particular gentleman says, you know what, my schedule's not super tight, I got a little bit of free time, maybe this change won't be that bad, maybe I'll end up liking it, but then again, maybe I'll hate it. Can he just tell the employer in writing, you know what, can I just try it for a bit? And if this doesn't work for me, back to the old shift.
Yeah, he may say, well, listen, I don't know how this is going to impact me, my family. Can I do it? Is it going to work for me? So, employer, I'm going to try this for a few weeks, and then I'm going to let you know if I'm unhappy. And if I'm unhappy, if I don't want to do it, if the employer doesn't take him back to the old shift, then it's still a constructive dismissal. But he has to say that in writing. If he doesn't say anything and he just continues working, he's going to be considered to have accepted this change, and then he's stuck. So if you're going to try a change out, a change in hours, a change in a new role, make sure your employer knows that you're not accepting it, you're not agreeing to it. You're just going to try it out for a while to see how it goes. As long as you do that and you put it in writing, you still have the ability to try it out.
Because as you've said so many times, if you do accept it and just go along with it to be, be the good soldier, the good employee, great intentions, but it also means that they can do it again down the road.
Well, this person, their shift is changing from 8 to 4 to 12 to 8. He accepts it. He wants to be that good soldier. Well, by accepting it, now his employer has the right to do it again. And next time when they change it from 12 to 8 to 4 p.m. till midnight, he may not be able to do anything about it because he let the change happen the first time. That's why we can't ignore these changes. We always have to think, what will happen if I accept this change?
Lior and I and some other lawyers in his firm, of course, have been doing a radio show across the country for over 10 years. You want to find out a station near you that carries it. It's an hour long every week. It's fantastic stuff. Employmentlawyer.ca. Find the media tab and you'll be able to go from there. But we pull some of the phone calls from a variety of radio shows we've been doing for the decade. Lior, we play them back and we talk about them. Full call number one for this show today is coming up now.
I worked at a casino. I got laid off. Well, my job was no longer there. That was March of 2020, and I've yet to get an actual phone call from them. I was there for 17 years in a full-time position, and they've sent me some emails to come back as a contract position, working like night shifts on the weekend. We're not unionized, and I'm just wondering if I'm entitled to any severance.
Wow, March 2020.
That's a long time. And listen, casinos and casino employees have been in a very difficult situations because depending on your province, for the most part, they were required by government to be shut down, to be closed. But that ended and casinos were allowed to reopen. And once they were allowed to reopen, employees have to be brought back to the same position, same terms, same compensation, etc. Well, that's not what this person's employer is doing. They're saying, we're going to bring you back, but not even as an employee, as a contractor, on completely different terms. Well, hopefully you remember what I said moments ago. They can't do that, even if it's because of the pandemic. It's a constructive dismissal. So he can obviously accept this change. I don't know why he would. It's a pretty major change. Or he can say, no, I am treating this as a termination. This is a constructive dismissal. Now, employer, you have to pay me my severance. How much severance? Well, let's talk about that. To find out how much severance he is owed, to find out how much severance you're owed, let's go to pocketemploymentlawyer.ca. Let's plug the information into our severance calculator, by the way, free and anonymous, and let's see how much this person is owed. So he's a 48-year-old floor supervisor. We know he's been there for 17 years. It's a long time. You can see right at the bottom, he's owed 16 months pay. And by the way, John, that could actually be conservative. It could be as much as 18 months pay. So somewhere between 16 to 18 months pay he's owed. At his compensation level, we're talking about a significant amount of money, almost 6 figures. And that's why it's important to remember with constructive dismissal, with any termination, you have significant entitlements, and pocketemploymentlawyer.ca the easiest, fastest way, most accurate way to find out how much you're actually owed.
Yeah, and on that website, as Lior mentioned and just used, Severance Pay Calculator has been used, and this is not hyperbole. Hundreds of thousands of people over the last several years have plugged their information into that. And it's been a bucket of water in the face when they realize how much they're actually owed, conversely to what they've been told by their employer or a friend or their neighbor, Steve. Don't go there. Pocketemploymentlawyer.ca and use the Severance Pay Calculator. Another place for you to ask questions anytime, terminationquestions.com. We'll get to one of those. This time it's Akari. Lior, Akari says, I was fired for cause after an incident occurred with another co-worker. This was the first and only time I've ever behaved this way at the office after 8 years of employment. And the co-worker has a history of making things difficult for other staff. Can they do this?
Well, John, this brings up, of course, the issue of a termination for cause. So let's talk a bit about that. This person got into some sort of an altercation and he was fired for cause. For cause means his employer's not paying him any severance. Well, the only time you can be let go for cause, i.e. without severance, is if what you've done is terrible. If you're guilty of the worst sin, it can't be worse. So it's only the worst offenders that can actually be legally terminated without severance. The fact that he may have done something wrong, and getting into an altercation is never a good thing, so he did something wrong. But the fact that he did it does not mean that that rises all the way to the level of cause. If this is an isolated incident, if it's not a situation where he went and assaulted someone and then used violence, he got into an altercation, it's not going to be cause, no chance, meaning he is owed severance. So the message here for every employee is this: even if you've done something wrong, frankly, even if you've done a few things wrong, if you're let go, doesn't mean that you can be deprived of your severance. It doesn't work that way. It's very difficult to terminate someone for cause.
If you were to take 100 employers that have just snapped and fired an employee for cause, claiming cause, I mean, what would be the percentage of the ones that, as you say, pull the trigger too fast? I imagine it's pretty high. They haven't done the due diligence, right?
Yeah, well, absolutely. And employers oftentimes equate doing something wrong to termination for cause. And as we've just said, that is not the case. To terminate someone for cause, either the person has to be guilty of very significant misconduct, or the employer has to provide advanced warnings and give opportunities to improve, and then and only then can they consider termination for cause. The vast majority of people, when they come to speak to me, probably 90% of the time, when the employer says, we have cause, it's actually not cause. Not because the employee has clean hands necessarily, only because it does not rise to the level of cause. It is very difficult. It's the capital punishment of the employment relationship.
And finally, on this topic, if you're an employer and you're looking to let somebody go for a cause, I mean, how much of a workup to have to do? How many warnings and how many times you have to write them up before you can, have a clean slate to say, now finally I've done what I have to do, you are gone for cause with no severance?
It really does depend on the type of issues that the employee is creating. Right. So if it's a performance-related issue, at a minimum, I would want to see 3 warnings. 3 situations where there's something in writing saying, employee, you better do better or else. And after a while, if the employee still is not doing a good job, well, what more can you do? So as a rule of thumb, 3 is a good place to start. In some situations, you need more than that. In other situations, if the misconduct is very bad, you may not need 3. But as a basic rule of thumb, 3 is good.
Coming up, as we mentioned, what independent contractors need to know. If you're an independent contractor, do not tune out. Stick around for this next segment of the show. I'll give you some contact in the meantime as we go to break. 1-855-821-5900. Email help@employmentlawyer.ca. We'll continue. Employment Law Show. More coming up. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. Thank you so much for sticking around. Employment Law Show. John Scholes here. Beside me, Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP. They are the most positively reviewed employment law firm in the land. Reaching out, 1-855-821-5900 and the website pocketemploymentlawyer.ca. Important segment this time around, Lior. I mentioned this off the top. It is so important because so many people will fall under this particular category. What independent contractors need to know. How many phone calls have we had on our show with people going, oh, I didn't know that? Pretty much countless, right?
It's one of the biggest things when it comes to employment law is individuals being misclassified. So we want to talk about who really is an independent contractor, what to do if you're not really one, and how the law deals with the situation.
We're going to start off with a big one. That is, many independent contractors may truly be employees despite what an employer or their contract says.
So it does not matter what you sign. It doesn't matter if you sign a piece of paper that says you're a contractor or you're not an employee. You may have signed a piece of paper that says in big bold letter, you are not an employee. Guess what? It doesn't matter. You're likely an employee because the only one that can decide if you're an employee or not is the law. The law makes that determination. You don't do it. The company you work for doesn't do it. I don't do it. The law does that. So if you look like an employee and act like an employee, you are an employee. And being misclassified is very, very, very common. I had an email discussion with an employer recently where I was retained by an independent contractor, and I contacted this employer saying, well, no, this person is an employee. And this company couldn't understand. Well, wait a second, Mr. Samfiru, can't you read? Look, this person signed a document saying they're not an employee. Look, it's right there. It does not matter what you sign. You can change the nature of your job and the character of your situation by signing a piece of paper.
Number two is this. There are ways to determine whether someone is a contractor or an employee. Very simple, right?
Well, so it has nothing to do with what you signed, but here's what you need to know. So how do you determine if you're an employee or an independent contractor? Well, you ask yourself, am I in business for myself or do I work for someone else? If you work for someone else, you are likely an employee. So let's use my plumber example. I love to use my plumber example. So you have a leak in your faucet, you call a plumber. The plumber doesn't work for you. He works for him or herself. They come to your place, they provide a service, they do the job, you pay them, and they go to their next job. That is an independent contractor. They're not your employee. They have many clients. They run a plumbing business. On the other hand, if you run a plumbing company and the plumber works for you, they're your employee. So ask yourself, am I the plumber or am I something else? Who controls what I do? Do I work exclusively for one company? Do they pay for my expenses? Do I have to report to them? Do I have other clients? There's a number of factors to look at, but it does not matter what you signed, and you're likely misclassified if you're not sure one way or the other.
We were talking about what employee contractors, or at least people on contract who think they are independent contractors, need to know. Point number three is this, Lior. Employees incorrectly classified as contractors are missing out on basic rights and entitlements. How about that?
So what does it matter if you're an employee or a contractor? It matters because if you are really an employee, you're owed a bunch of things. For example, you're owed overtime pay, vacation pay, statutory holiday pay, minimum wage. All these entitlements that you have if you are an employee. Now, the company may not pay it to you because they say, no, you're an independent contractor. But if they've misclassified you and they should have been paying it to you, then they owe you that. And you can potentially go back a couple of years to get paid what you're owed. So that's why it's important to get this right. The other reason why it's important to get this right is that if you've been misclassified and now you're paying your taxes as an independent contractor, well, CRA may one day and say, well, wait a second, you're really an employee and you've been paying your taxes wrong. Now there's going to be fines and back taxes and penalties. So you really, really do want to get this right.
Next point is this. Independent contractors are often owed severance pay when they are let go or fired. I can imagine how huge this would be if someone's been a contractor for 15, 20 years, right?
So most of the time when I get involved in these situations is when someone has actually been let go. and the company says, well, you're an independent contractor, we're letting you go, we're going to pay you nothing, or maybe we'll throw you a week or 2 weeks pay because you're an independent contractor. But again, if this person has been misclassified, then they're owed severance like an employee, and that could be as much as 24 months pay. So if you lose your job, unless you're 1,000% convinced that you're an independent contractor, and even then, you have to give me a call. I spoke with a lady a couple of years back. She had worked as a bookkeeper for the same company for over 20 years, and she was let go, and the company said, you're an independent contractor. Nonsense, impossible. She was an employee. Yeah. She was owed 2 years pay, and I helped her get it. Same thing with you. If you lose your job, you are likely an employee. Most people are. Despite what you've been called, that means you're owed severance.
And final point about independent contractors is this: contractors should always talk to an employment lawyer if changes are made to their job or if they're let go, especially like that.
Well, absolutely. If you're an employee, you have the rights of an employee, including the right not to have the terms of your employment changed. And by the way, John, we talked about the difference between employees and contractors. We also have our tool at pocketemploymentlawyer.ca that allows you to find out if you are an employee or a contractor. So you go to pocketemploymentlawyer.ca, scroll there to our independent contractor tool, you answer a few questions, and you can find out, are you really a contractor, or have you been misclassified and you really are an employee? Probably the first place you want to go to, if what we've said here on this show triggers some questions in your mind, check it out for yourself.
Plus, I mean, if it was really that easy, the entire planet would be full of contractors, and employers wouldn't have any sort of, repercussions of paying severance or otherwise. Oh, you're all contractors. Doesn't work like that.
Well, absolutely. I think if it was that easy to do a piece of paper, everyone would go on their laptop, write up a quick document saying you're a contractor, and everyone would sign it. Doesn't matter if you're working part-time in a fast food restaurant, if you're a secretary, if you're working at a factory, everyone would be contractors. Clearly, that's not the case. That's why the piece of paper doesn't matter. What matters always is substance over form.
Employmentlawyer.ca, that's the firm website. As mentioned before, media tab to find a radio show near you across the country, carried quite widely. We'll get to another phone call from our radio show before we break right now, Lior. Listen up.
My wife was working for a very important construction company. She worked there for 2 years, and then when she got on mat leave, close to the end of when she had to return to work, they sent an email saying that right now you're laid off. She pretty much got laid off. They just said, due to COVID, like it was COVID time, they said, you cannot come to work right now. We're just going to lay you off.
So there's a number of things here, but I want to start with the fact that this is something that people get wrong all the time. And that is, people that work in construction are still owed severance. In fact, they're owed the same amount of severance as non-construction employees. It's based on your age, your position, and the length of your employment. So she's owed severance, assuming, of course, she is not part of a union. She's owed severance. So if they let her go, she's going to be owed that compensation. Even after 2 years, she could be looking at as much as 6 months' pay. But there's another issue here, is that if she's been let go, even in part because of the fact that she took a maternity leave, that's a human rights violation. That's a violation of the Employment Standards Act. It's illegal. You cannot be let go in those situations. So severance, potential human rights violation. Yeah, this employer did it wrong. If you find yourself in any of those situations, you have to reach out to me right away.
Short break, and we'll take another phone call on the other side. In the meantime, here's how you reach out to Lior and the rest of his team. Very capable, always good for a chat. 1-855-821-5900. help@employmentlawyer.ca. That's the email address. We're coming back with more Employment Law Show. People think contractors aren't owed severance. Employmentlawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. Employmentlawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back. A few minutes to go here on Employment Law Show. Thank you so much for spending some of your time with us today. Want to get to our third phone call. Again, our radio show, employmentlawyer.ca, the website. Under the media tab, you'll find a station near you that carries it. It's an hour long, always stuff to be learned. Lior, phone call number 3 is coming up right now.
I've been an executive for a company for 20 years. The company was bought out 3 years ago. The new owners, they sent a letter to all of us saying that they will not be changing anything in terms of our employment contract. Now they have just sent us a new employment contract 3 years later. They have waived the common law severance terms. I just don't know what to do. What are my options?
Crumple it up and throw it away.
I mean, I couldn't say it better myself, John. The option is you do not sign this, because if you're going to sign this, all of a sudden now you're going to limit your future severance to as little as 8 weeks pay. So it's always a bad idea when your employer wants you to sign a new employment agreement, and usually it's because they want you to agree to give up your future severance. So I can assure you that if this person were to sign this agreement, she's now limited to 8 weeks pay. Well, how much would she owe? Does it really matter? And would she have been owed more if she hadn't signed it? So to do that, and just for fun, let's go to pocketemploymentlawyer.ca. Let's use our severance calculator, and let's see what she's owed if she doesn't sign this piece of paper. So we know that this person is an executive role, has been there for 20 years. Let's say they're in their 50s. You see right at the bottom that this person would have been owed as much as 2 years' pay, 24 months pay. So if she signs the piece of paper, 8 weeks. If she doesn't sign it, 2 years. So the difference between 2 months and 2 years, now you understand why you cannot sign this employment agreement. It's as simple as that, John.
Do you think it's the case sometimes where these employers have either heard our show, maybe saw us on TV, maybe heard the radio show, and then maybe they got some advice saying, oh, you know what, why don't you get some new employment agreements to your employees before you get in some deep trouble? Maybe that's why all of a sudden this has come on our desk?
Well, let's be very clear, John. For an employer, one of the most important things that you can do is to have proper, comprehensive employment agreement. It's the best thing that you can do for your business. So I can't blame employers for doing that. For employees, the opposite is true. You don't want to have an employment agreement. You would much rather either have worked on a handshake or go to the pub and write something on the back of a napkin. That is better than having a 10-page employment agreement. So that we have that conflict between employer and employee. But if you're already working, why would you agree to give up your legal rights by signing an employment agreement that gives those up? Frankly, it'd be better to lose your job, get paid your full severance, than to sign that employment agreement. At least you'd get your full severance. In that situation we just talked about, if she signed that employment agreement and the employer turned around a week later and let her go, she would have lost on 6-figure worth of severance. Yeah. Terrible thing to do. Never, ever do that.
Even if she did sign it, doesn't she have to be given something for it to make it even binding?
Yeah, if you're already working, your employer should be giving you something in return for signing. But that's kind of the next level of analysis. On a most basic level, I say, if your employer wants you to sign it, you say no. Nothing good can come out of you signing a new employment agreement.
Yeah, like you said, you want a handshake rather than a 10-page document, which is counter to what most people would think. They want this, but they don't need that.
For an employee, less is more when it comes to employment agreements.
And that's the way we're going to leave it for today. Reaching out, really simple. Phone numbers first, 1-855-821-5900. You want to reach out through email, that's simple as well. help@employmentlawyer.ca. If you shrink that down to just employmentlawyer.ca, that's the firm website where you get the radio calls, right? And you can find a radio station near you. And Pocket Employment Lawyer is always free and anonymous as well. Thank you so much. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.